now we've taken care of the medical side.
Yeah.
Now we're going to transition to the general power of attorney?
Yep.
Okay. So can you tell everybody what that means?
Sure. Okay. So the next thing that we are going to go through is the general power of attorney. Sometimes you may hear it called a durable power of attorney or just a power of attorney. That is where you are nominating, very similar to what you did before, you are nominating an agent. You are nominating someone to make not healthcare decisions for you like you did on that last form. This form, you are nominating someone to make business, legal, real estate, any type of transactional decisions that need to be made in your life. This is where you're nominating that person. And that person would be called your power of attorney. So this is what that means, is you've nominated someone to make legal, real property decisions, transactional decisions, business decisions, finance decisions, everything that's not medical, basically.
And am I doing this because I'm sick? Am
Very
I
good
doing
question.
this? Like, why do I need to do this?
Very good question. There are a couple of different ways that this document could come into place. One could be, yes, you are sick. You cannot make these decisions for yourself. You're in the hospital, you're in the coma, you're in the vegetative state, but your business needs to keep running. Who are you nominating to make those decisions for you? Again, remember, this is very different from your will and trust because you are not dead. You're still alive, still very much alive, but you can't make those decisions for yourself. However, there are multiple types of powers of attorney, and I want to discuss those. One is a durable power of attorney. So what that means is that the document is effective upon you signing it. So if you sign the durable power of attorney today, it is effective today. So let's say you nominate Janai. Let's say I nominate Janai to be my power of attorney. So she can make business decisions for me. She could go to the bank, take out hundreds of dollars out of the bank. And I just gave her that right today. And she goes,
you're not sick.
And I'm not sick.
Right.
I'm totally not sick. This document's effective today. I'm still here. I'm still breathing. I can still make decisions for myself. But Janai goes to the bank and takes out all my money tomorrow. So someone may say, Tiffany, why in the world would I do that?
Right.
Why in the world? The reason is because most states are going to require a determination of incapacity if you did it the other way. So if you said, I only want Janai to be able to go take hundreds of thousands of dollars out of the bank if I'm incapacitated, someone is going to actually have to deem you incapacitated. That could take months. That could take several months. That could be expensive. You have to go find a doctor. They then have to go do tests, all that stuff. And I need Janai to go get the $100 out of my bank account tomorrow. Like, we need to move.
Right.
So, and we had discussed this earlier, is what I tell clients is don't tell your power of attorneys that you've named them until it's necessary. Until I really need Janai to go to the bank, she doesn't even know she has the authority to go to the bank. And that way it is a durable document. It's effective today. I don't need to wait for a doctor to deem me incapacitated.
Right.
But as soon as something happens, Janai can go get the money out the bank.
So where should this document be so that way the power of attorney will know when it's time for them to kick in?
Again, so that document should be at your home.
Okay.
I would recommend scanning it, putting it in your email box. I know if you have an iPhone, you could put it in your folder. You could put it there so you could email it out quickly. But again, this document should not be in a safety deposit box because you might need it in the middle of the night. You might need someone to gain access to it. Again, I recommend putting it in a fireproof safe that you can just order or get from Walmart, and letting your loved ones know where your documents are, but not necessarily telling them
What
that
their
they
job
have the
is.
power to
Right.
do it.
What their power is. Okay.
Yeah. So that's a durable power of attorney. Many states have that as kind of the baseline. So once you sign it, it's effective. Your people can go do the things that you are giving them the authority to do. The other option is what we call a springing power of attorney. So it only comes and springs into effect on some occurrence. So you could write, if I'm out of the country, this power of attorney comes into effect.
Okay.
If I'm deemed incapacitated, this power of attorney comes into effect. That's a springing power of attorney. Something has to happen for the power of attorney to take effect. A lot of states do not allow them. Georgia does. Florida, for example, does not. So there are some states that do not allow that springing power of attorney. Another type of power of attorney is a limited power of attorney. So it's very much similar to what it is we're doing, but you're giving your power of attorney, your agent, limited powers. So this comes into effect quite often, let's say, for real estate transactions. So if you need someone to be able to sign a deed for you for this one property, you can do a limited power of attorney. So Janai has the power to sign the deed for XYZ Street property.
And then that's it.
And that's it.
I have no powers beyond that.
Exactly. She can't go to the bank. She can't look at any other transactional documents. The only thing that I'm giving her is the limited power to sign the deed for XYZ property.
Okay.
That's a limited power of attorney. That's another one that can be done. But that's kind of the background of these power of attorneys. They are, as you look at them, the form that is more robust and the Georgia form, you'll see that there are a lot of powers in here. A lot of things. We kind of throw the kitchen sink in there because you never know what could happen, or you never know what it is you want your person to be doing. But let's go ahead and look at the Georgia one first, and then we'll go through the other one. They're very similar. It's a lot easier than the healthcare directive. It's the...
So while Ani is pulling that form up, this is the time to really think about who you want to pick to be in charge.
Yeah.
Because that's where they all begin. Who do you want to be your agent or agents? You know, who are those people that you trust?
Right.
If something happens to you, you know, maybe you have COVID. Maybe you are in the hospital for 4 weeks, 6 weeks. How many of these stories have we heard?
Yeah.
And someone has to transact business on your behalf.
Correct.
Who is going to call your employer, pay your bills, talk to your mortgage company, because you know they're not going to talk to anybody.
Yeah.
They can't. They can't. So this is really, really important document, but it's interesting to think that there are a lot of people that you should not tell that they have this power.
Yes. We see a lot of abuse, especially when it comes to the elderly with these.
Oh, yeah. It's too bad.
It's sad. So
yeah.
So again, it's very similar to the medical power of attorney about who is the right person.
Right.
Again, it's someone you trust, someone who's competent. What's a little bit more different from the medical one than this general power of attorney is sometimes you may want to nominate someone who is good with business type decisions.
Yep.
So someone who can pick up the phone and talk to the bank or talk to your insurance agent, those types of people that have those types of skills and are able to do those types of things. As well, just like the medical power of attorney, someone who is capable and willing and able to act. A little bit different than the medical power of attorney. You likely might not need someone in person for this one because so much transactions are done online. Your power of attorney likely could get forms done and scanned and emailed. They don't actually have to be in a hospital type of thing. So you don't as much need someone who is local to be your power of attorney. And again, the power of attorney can be revoked at any time. You can change your people. Same like the medical directive.
Important to know.
Yeah. All right, let's go through it. So first up, this is the Georgia statutory form power of attorney. That first line up at the top, you'll see state of Georgia, county of blank. This is for your notary. This document needs to be notarized. So your notary is going to fill in that county of blank. So you can leave that alone. Your notary should know that that's where they're filling in some of their information. Right under statutory form power of attorney, you are going to put your name. So delete out client name, put your name. Designation of agent. Let's scroll down. This is where you're naming your person. So client name, so your name, name the following person as your agent. You can put in one person. You can, like I said, copy and paste this block, put in two people. You can put in two names under the name of agent section and put in two addresses, etc. But same thing, giving the contact information for your agent. Designation of successor agents. This is optional, but I do highly recommend that you put some successors in there. So if your first person can't serve, this is that Jane, then John, then Janai succession. Again, naming some people who could be your backup agents. So that's that section there. Now, grant of general authority. You'll see a lot of paragraphs here. I will say 90% of my clients don't read all of these, but you can if you want. These are basically all of the powers that you could be giving your power of attorney. So, for example, the first one is real property. So they could execute deeds on your behalf. Tangible personal property. Let's say you've got stuff. You're going to say, my power of attorney can sell it. They can transfer it. They can give it to someone else. They could gift it. Stocks and bonds. Dealing with your stocks and bonds if you have any. Options if you have any. Dealing with banks and financial institutions. Signing checks. Taking money out of the bank. Operating your business. So if you've got a business, they can continue to operate it. They can deal with insurance. You'll see the list goes on and on and on. These are all the powers. But what I want to point out is there's a little line next to each one of these. This is where you would initial if you want your agent to have those powers. So, for example, we've got on the screen right now taxes. You see that little line right to the left of it? That's where you would initial if you're fine with your agent having the authority to deal with your taxes. You'll see right under the taxes paragraph. It's kind of an easy, the lazy way of doing this. If you agree with all of the powers and you're like, my agent can have all the powers, you can literally just initial all preceding subjects instead of initialing every single one. So you could do that instead.
So check your state just to make sure, how things are listed. I'm assuming they all probably
all look like that, yeah.
So if you're just going to give them all the powers, just go ahead and initial that one section.
Now, this section, grant of specific authority. Now, this is an optional section too. So what I call these are superpowers. Okay. These are really, really big powers. These are kind of changing many different plans that you have in your life. So, for example, the first one on here is you would give, if you initialed this one, you would give your agent the right to change all of the documents we're doing today. You would give them the right to change your will. You would give them the right to change your trust. That's a big deal. So that's why these are called superpowers. These require you to initial next to every single one that you want because the state wants to know that you actually read these because these are a big deal. I will let you know that I recommend to my clients that they actually don't sign these. I think they're too big of powers. The only one that I recommend and that I've signed myself is if you scroll down to access the content of electronic communications.
Which I could see why that would be important.
That one I think is important. So that is, again, we had discussed this before, your digital assets. So you're allowing someone to go into your email, go into your Facebook, go into your Instagram, go into accounts that you would access on a computer or a tablet. That I think is a good power to give someone. And that one I would recommend that you sign. The other ones are, like I said, superpowers. You're changing really, really big things. And I don't often recommend that you're signing them unless there's a specific reason to be signing those. Let's go to the special instructions section. This is kind of a catch-all paragraph. So this paragraph is stating that if you initialed next to any one of those powers in those preceding pages, and that paragraph that you initialed next to didn't encompass one little minute thing that we, for some reason, didn't draft in this long list of powers, that as long as it's related to the overall power, you give them that power too. So you would initial next to that. So this related power basically says, so for example, so let's say it's the access digital communications paragraph that you initialed. You said they can access my digital communications. But that paragraph didn't say something about NFTs, for example. And your person needed to get an access to an NFT. That's still a digital communications. It's related. So they then have that power too.
Okay.
So that one, I do recommend you initial next to that. This basically states that this is effective as of the date of signing. So Georgia requires it to be durable. This form is durable. It also allows you to nominate a conservator under this form. So again, that's that person who could make financial decisions for you if you're unable to. Reliance on this power of attorney. This basically says any person has to rely on this. So if your agent takes this form to the bank needs to listen to it. They need to follow it. All right, and then we're going to go to the last page. This is the signature page. You're just going to date it, replace where it says client name, replace it with your name, and you'd sign right above that line. Again, everywhere what says client name, you'd replace it with your name. You would have an unofficial witness. So again, it has to be someone that's disinterested, someone who's not named in the document. They would sign above that first line that says unofficial witness, and they would print their name on that second line. Then you would have a notary fill in the last part. Again, you'd replace your name with client name and have the notary go ahead and put their notary stamp, put in their date of expiration. This document is prepared by, you could just delete that paragraph because I would not be preparing it for you directly. So you could delete that paragraph. So that is the Georgia form. Let's quickly look at the other form that we could use for multiple states, and you'll see it's very, very similar.
So again, ladies, please make sure that you are looking at your state forms. And if you have any specific questions about your state forms, please drop them in the chat or raise your hand. That way you can take advantage of Tiffany being here. This is huge. And I know it's late, but this is so worth it.
All right, let's pull up the next one.
Yes, we do have some questions.
Okay, so while Annie's pulling that up, what are our questions, Tiana?
Luo asks, why do you recommend the digital access?
I recommend it because there are so many things that people have that are stored digitally these days, that are stored in your email, pictures, accounts, things like that. It's not necessary. So if you don't have a lot of digital assets, if you don't have a lot of stuff, in your email box or on your computer, it's not necessary. You don't have to do it. But for those of you who store a lot of things electronically, I would recommend it.
Sonia asks, if someone is on your bank account, do you need a DPOA/FPOA?
Very good question. So let's say you've got a joint bank account with a spouse or a loved one. That person already has access to the account because their name is on it. So it's not necessary for you to do this particular form for them to access that account, but you still might need this form for any other transaction. So maybe it doesn't have to do with the account, but it has to do with your insurance, or it has to do with, the DMV, things like that. So I would still recommend this form.
Awesome. And then Kimberly asks, will your state's form be honored if traveling in another state?
Very good question. Thank you for asking that. Yes, there is the full faith and credit clause, which is in our United States Constitution. What that means is that any state has to recognize another state's laws. So basically that means if you signed your document in accordance with your state's laws, any other state has to recognize it too.
Great question.
Very good question.
Very good question.
Yeah.
And then one more. Sonia asks, what can you do if you own a home, you pass, but you want someone to take ownership of the home? What type of document do you need?
Very good question. If you pass away, remember, these forms that we're filling out today are while you're still alive.
You're alive. Yeah.
The wills and the trusts are the documents that you're going to need to handle assets when you die. So that's the document that would then come into place. So as soon as you die, you could literally just throw these in the trash. Yeah. They are no longer effective when you die.
Everything changes.
Yeah.
Yeah.
Then I had a question.
Sure.
Okay. And I do too. Go ahead.
How does it work where, giving the bank these documents? communicated via email? Like, I'm assuming you can't do it on the phone. Like, how does that actually?
So most often they're going to want the original. That's why I was saying it's really important that you have access to the original.
For sure.
The bank, usually you're either calling them or going into the actual branch and you're saying, listen, I am power of attorney. I need to access this. And then the branch person, usually the teller, it's a little bit above their pay grade. They're going to send it to their manager. The manager is then going to say, we need to see a copy. We need an original. Please bring it in, mail it, FedEx it, etc.
One thing that I learned when my mother was terminally ill was her documents weren't updated. So I got the power of attorney done literally when she was in the hospital, and it empowered me to go to the bank, take care of a lot of business. But it would have been, and literally, I think she died like the next day.
Oh, goodness.
And so, I mean, I literally just made the cutoff. So I'm saying all that to say, if you have anybody in your life that you know is ill, don't wait.
Yeah.
Like this is great. I need you to get your forms taken care of, but it will make a world of difference to have powers when your loved ones are ill.
Right.
So please, please, please move very quickly.
The other thing is, and I'm glad you brought that up, is you can bring these forms once they're signed and go ahead and give them to your bank. So they already have it on file. They will save it with your account. So you could go ahead and go in there preemptively and be like, listen, I just filled out these documents. I want you to have a copy now.
Good to know, too.
Yeah.
Is there a reason you wouldn't recommend just to add that person to the account as a joint owner or whatever, you know?
Sure. So you can. Some people don't want them to have that access until it's absolutely necessary.
All really good questions. Okay.
Okay. So we've got the other form up. As you'll see, it's very similar. At the top, you're going to, again, replace your name everywhere it says client name. That first line, I, your name, a resident of your city, your county, your state, hereby appoint, and we've got a little option here where you could put spouse, husband, etc. We've got an option where you could put an and, so if you want a co-agent, as my true and lawful attorney in fact, to serve jointly, to serve by majority rule, to serve or to act alone. So we've got a couple options in there for you. Here we have highlighted, this is that springing option. If you want it to be springing, so only upon your incapacity, if we can go back up, sorry. You'll see that bolded section, sorry, not highlighted, bolded, such appointment to be effective only upon my incapacity. That would be that springing option. If you want it effective now, you would delete that bolded section.
And remember, that's for Georgia people. Remember, Tiffany said that. A lot of states do not accept that.
Right. And then section 1, we've got durable highlighted. Durable just means effective now. So if you don't want it effective now, you would delete that durable word. Power of attorney, law of, insert your state. That's that only place where you have to do some manipulation to that paragraph right under general powers. Then everything under section 1, those same powers that you saw before, all of the same provisions that you saw before. You can delete anything you don't want. You could change up something if you wanted to, etc. You'll see starting section 1.12. This is where those superpowers come in, like I said before. Optional provisions, change your trust, things like that. Those you could delete if you don't want. If you want some of them, you can keep them in. Those continue. Section 1.17 is where it ends. Those superpowers, ends. 1.18 is just some more powers. Do you want them to be able to make gifts on your behalf? Do you want them to be able to make charitable gifts on your behalf? And you can kind of delete as you see fit. And it just continues. All of these powers just keep going. You'll see 1.30. This is that digital assets section again. So access to your electronic communications. If you don't want it, just delete the paragraph. Section 2. If you keep going down, this is where you name backups. So if your primary agent or agents, if you've got two, can't serve, this is where you're naming your backups. Again, most of the highlighting here is just regarding whether or not you've got one or two people. Section 3, again, you've got 3.1, the ability to appoint a conservator, your agent to be your conservator. 3.2 is where you can add a provision that says this is revoking prior power of attorneys if you wanted to. Section 3, which we actually didn't talk about in the other one, is compensation. Do you want your attorney to be compensated? And you can put that in that section 3.3 if you wanted to.
Obviously not required.
Not required.
Okay.
Yes. 3.4. So let's say you wanted it to be a springing power of attorney. What that means, again, is that a doctor is going to have to deem you incapacitated. And what that means is basically under that section 3.4. So it basically says how a doctor can deem you incapacitated. That's that 3.4. 3.6. These are excluded powers. These, I agree with all of them. So I would leave all of these here. So you're basically saying your attorney, in fact, does not have the power to edit your will or to make a will, to carry out any actions specifically forbidden by you, to exercise any powers you may have as a trustee. Let's say you are personally a trustee for someone else. That power of attorney can't just step in your shoes for someone else's documents. Things like that. 3.8, very similar to the Georgia document, actions of your attorney, in fact, are binding. So if they go to the bank and show them this form, it is binding. 3.9 is basically stating that this document could be copied, that the bank could look at a copy. I will let you know that banks, most of them, are going to require an original, even though. And then you'll see the next couple pages are, again, those state-specific signature requirements. So that's the end of that one.
Any final words, Tiffany?
Well, this was good. I thank you all for sticking around.
I know it. I know it.
It's a
It's
lot
worth
of
it, though.
information,
I know.
and I appreciate you all being patient, for taking an interest in this. It is so important. I can't stress that enough. If not for your sanity, for your loved one's sanities, to make sure that things are in place. And again, you guys will get my email address. I'm happy to answer any questions if you stumble along across the way. I obviously can't draft the document for you unless you retain me as your attorney, but I'm happy to give some more tidbits.
So we will make sure that you have Tiffany's information, and please follow her on social media. That's Tiffany.n.McKenzie, and that we will work to get another session scheduled with her so we can focus exclusively on wills. And thank you all for being patient.
Yes.
You know, we knew this was our first working session. We knew it was going to go long, but it is so important.
Yeah.
And again, I have been in charge 5 times now when someone has passed away, and it is a completely different experience when everything is tied down.
Yeah.
You know, when you know where everything
Yep.
is, you have all the documents, like you could just go and execute. And now only thing you have to do is just mourn.
Right.
And not be stressed.
Right.
So please, please, please take the time to do it. And thank you all for trusting us. Thank you, Tiffany.
Of course, of course. I have one more thing to say.
Okay.
And this is something Janai and I have talked about a lot. What's also really important is that your loved ones know where your documents are.
Oh my gosh.
Huge. It seems very simple,
Yeah.
but it is huge. If they don't even know where to go
Yeah.
to find out what assets you own, to find out what accounts you have, it is only setting the process back further. Yeah. So it's really important that you don't have to tell them what you put in it. You don't have to tell them who you named. Just tell them where to find it.
Yeah. And then if you're somebody like me who's worked with someone like Tiffany, like my children have Tiffany's contact in their phone. So like this is who you call.
Right.
Go ahead and get the process started. So please make sure of that as well.
Yep. That's it. I'm
Okay.
done.
Thank you for being so
Of
generous
course,
with your
of course.
time. We really appreciate it. And thank you Thank Me Later team
Yes.
for bringing this all together tonight. And August, again, we knew that this was a heavy month. This was a heavy lift. It took a lot to plan and just psychologically get ready to do the work that we have to do. But again, we have to get the work done.
Right.
Ladies, we have to get the work done. Thank you for joining the Thank Me Later community. We need your suggestions. Anything else you'd like us to cover, let us know. Thank you for engaging with us. Have a good night.
Yes.
And please invite your family and friends. Females only, of course. This is ladies only. We've had to deny some men, but that's okay. But again, thank you so much for engaging with us. And you can follow us at TML Money on social media. And you can follow me personally at Janai Thornton, JINITHORNTON. Good night, everybody.
Good night, everyone.
We will
Thank
post
you.
this maybe in about a week. So hold tight. Give us about a week and we'll get this posted in the community. Good night, everybody.
Good night.
Thank you.